Hello, folks. We're giving just a few more minutes for people to get here. But thank you for joining on time. But probably just another minute before we get started, if you don't mind. All right, I guess we'll get started here. It's about 2 after 12, and I know we have folks still joining, and that'll probably just keep happening. So I'm sure they'll catch up and join the wagon here. All right. Good afternoon, everyone. My name is Doug Amar, and I am the executive director of the Georgia Justice Project. And thank you for being here for our legislative kickoff for 2026. You're going to hear from a lot of different people and hear about a lot of stuff. I'll try not to talk too fast, but I do have a little bit to cover before I pass it off to one of my amazing colleagues here at Georgia Justice Project. So, with that, I'm just going to jump in and ask. Thank you, Emily. So, before I jump into sort of some what we're working on and what we've done. What I want to just sort of set the frame here for a moment and talk about Georgia's numbers. Unfortunately, the numbers that Georgia, some of you know this, but we don't have some good numbers on the criminal justice, the criminal legal front. We have this first part of this graph is it shows that we are number four in incarceration. This is as of 2000 or 2021. And as bad as that is, it gets worse because we are with the highest rates of probation per capita in the country for quite a while and well past even the next closest neighbors you see on the second chart there. And then the last one here, we also lead the country, which many people know this, with the percent of people who are under correctional control in Georgia and have led that number for since I know they've been keeping it for over 20 or 25 years. That these numbers, as stark as they are, we like to point out that you would think Georgia has a crime problem, but we don't. We're number one in correctional control, but we are number 24 in crime rate, which is obviously shows the disparity in what's happening in the criminal legal system. So this is just unfortunately painting a picture that says we continue to. There's lots of good work to do still on this front. So with that, let me just talk about our organization for a moment to say how we approach policy. This year, 2026 is our 40th year of being an organization. For the first 20 some years, we sort of did just one thing, the holistic criminal defense work, which we still do, and helping folks on the reentry side. Excuse me, didn't turn off my phone. Um, but then about in 2008 is when we sort of announced and launched our efforts around policy. And that came about because of our criminal records work and representing about 500 families mainly in the city here who had a criminal record that was affecting their housing. And that really sort of encouraged us to sort of push and change, not just change the law to make it easier for people to get things off their criminal record. So our criminal records work is about almost 20 years old. I mean, our policy work is about 20 years old. But it hasn't been with us the whole time. But there's a couple of key things about how we approach this. When we launched it in 2008, we have a philosophy. I like to call it a proactive philosophy, and we're really clear that we're trying to fight for something and not just against something. So when we talk even today, we're going to talk about things we are trying to create or pushing for and doing it in conjunction with others. But we're not so much focused on fighting against something. And it's not that we don't believe they're bad bills and things we don't like, but we're really focused on creating solutions that attack very specific situations with a specific solution. So a specific problem and a specific solution. And that's just our approach to how we approach policy. And lastly, I would say is that everything we do in policy is grounded in direct service. We are primarily still a direct service organization. We represent folks at every level of the system, from arrest to the court system, incarceration, and reentry. And we, the last few years, have been, really blessed to work with over 2,000 people a year in the various aspects of our work. Uh, but we're really clear that when we show up on the policy front, we're not going to show up for something that we, our lawyers, our social workers, and our team have not worked on or touched with our clients. So that really grounds us in our approach. So when we show up and talk about a solution and talk about a problem, it's something that our clients have experienced, that we've seen, and we've tried to work through on the ground. So this is just some key points about how we approach policy. And with that, I mean, I'm going to transition here in a moment, but just to talk about our most recent, work with a number of players on the passing of HB 582. And we'll talk about, a great win this year. It was a big win. We had a great success here with just recently. But this bill is a great example of our work on the ground, of working with clients for years, doing even homicide cases for folks who are survivors and not being able to get in evidence that about their being a survivor. And so this bill does a bunch of things. Let me just go to the next slide. And this is a lot of information. I don't expect you to absorb it all, but this bill, HB 582, we call it Survivor Justice Act, SJA, really does a number of things. First and foremost, we have expanded what can come into evidence on the front end of a case to really try to avoid convictions and certainly incarceration for folks who are victims or defending themselves in the midst of a difficult situation. There's also sentencing mitigation at trial, a bifurcated sentence aspect that should somebody be convicted, that allows for a judge to sentence separately and requires them to sentence separately and differently than otherwise, which is a huge change in the law. And of course, a lot of folks know this law now for the post-conviction resentencing, which has a couple different aspects to it, but for really allowing people who are in prison to have a chance to come back to court and have their case reheard with regard to sentencing, particularly those who have been survivors of abuse. And folks who even the DAs want to resentence now, they have a path to do it. So this bill does a bunch of things. It's an amazing partnership that we have worked on with a number of players, and you'll hear from some. But let me pass the ball right now to my colleague, Cooper, who's going to talk about a really specific situation that happened here in the last week or so. Cooper?
Thanks, Doug. Yes. First, I'm overall going to share a brief update and a bit more information about the current implementation and impact of the Survivor Justice Act. But first and foremost, the bright smile that you're looking at here is that of Nicole Boynton. And on January 5th of this year, and I've gotten emotional every time I've thought about or talked about this, so forgive me if I do. On January 5th of this year, because of the Survivor Justice Act, Ms. Boynton was released after serving 23 years in prison for killing her abuser to protect herself and her infant son. Ms. Boynton's original sentence in Cobb County was for life with the possibility of parole. She was only 18 at the time. And so following the passage of Survivor Justice, a pro bono team from Alston and Byrd, including a former GJP intern, working with the Georgia Coalition Against Domestic Violence, took the case. And GJP and GCADV, the Georgia Coalition Against Domestic Violence, provided technical assistance and feedback to the pro bono team on the petition. The team reviewed records, interviewed multiple witnesses, which included a neighbor who had heard Ms. Boynton's partner abusing her on the day of his death, and even flew witnesses in from other states to be available to testify at the resentencing hearing, which was quite emotional. At the hearing, the state consented or agreed to Ms. Boynton being resentenced to time served, and the judge found that there was evidence that she was the victim of abuse and that the abuse was a significant contributing factor to the offense, which is what the law allows. A few hours later, Ms. Boynton was free. She has bravely chosen to share her experience as the first person released under the new law, and that's what you're looking at, which is an AJC article released about a week ago, and Anne's going to drop that in the chat. So everything after that may sound a bit mundane, but I was just, one of our policy folks was just reminding me that a law is only as effective as its implementation. So we wanted to share a few more details on the next slide about how GJP and our partners are working to ensure that the law has the impact that it should. First, our partnership with the Georgia Coalition Against Domestic Violence. We are continuing to work very closely with them. We have weekly meetings to coordinate upcoming trainings, to strategize implementation, and to prepare for the launch of our joint resentencing intake. Also, in terms of training and technical support, with the GCADV, we've done 8 trainings since June of last year. These trainings have been for lawyers, experts, and directly impacted survivors. We've provided technical support to defense attorneys, public defenders, private attorneys, and pro bono attorneys for 16 cases in 6 different jurisdictions. We're currently planning a day-long continuing legal education, or CLE, on February 27th for lawyers on survivor justice, and also a training for the National Council of Juvenile and Family Court Judges in March. In terms of resource development, we've created one-pagers for attorneys that explain the Act, that give examples of potentially relevant evidence to use in a hearing under the Act, and that give tips and advice on trauma-informed practices. We're currently working on developing an expert bank, model petitions, and model orders, which will also, of course, make it easier for attorneys around the state and for directly impacted folks to have access to the relief that this law provides. And then finally, we are preparing to open our joint intake to take cases with GCADV for resentencing at the end of January. So with that, I'm going to pass to my colleague, Anne.
Thank you, Cooper. As you can tell, we're very excited about the Survivor Justice Act. It's a big win for a lot of people around the state. So we want to tell you also about some other laws that we've passed recently, because as Cooper said, a law is only as good as it's implemented and the impact that it has. So we want to share about some other laws that might assist you or other people that you know. And after I'm done speaking, I'll put some links in the chat about that. So prior to the Survivor Justice Act, we were able to pass 2 laws related to driver's license suspension, which is unfortunately very common in Georgia and is often maybe possibly the first thing that gets people caught up in the criminal legal system. So prior to 2022, a person who missed traffic court, even for something as minor as a speeding ticket, would automatically get their driver's license suspended and could not get it back until they were able to pay off all the fines and otherwise complete the entire case. But now a judge is not required to automatically suspend the license, and there's a streamlined process for someone to get their license reinstated even before they can pay off their entire ticket. So these 2 bills help someone get their driver's license back and get it more affordably by doing 2 things. One, it allows judges to waive reinstatement fees for license suspensions come from missing traffic court. And second, it expands the Department of Driver Services reinstatement waiver, called the Pauper's Affidavit. So qualifying low-income individuals can now get their license reinstated, usually get most of those fees waived. So again, I'll put a link in the chat soon for more information about how you can advocate for yourself in those situations. Probation, Senate Bill 105. As Doug mentioned earlier, Georgia has the highest rate of people on probation in the country. 3 times longer than the national average are our sentences. So many states cap their probation sentences at 2 or 3, maybe 5 years. But in Georgia, 40% of our probation sentences are longer than 10 years. But we passed a new law, Senate Bill 105, that allows people to terminate early after 3 years that meet certain criteria. So far, 20,000 people have been able to terminate their probation since the law passed. So you don't need a lawyer to pursue this process. So again, I'll put a link in the chat. It's a great opportunity for many people, and we hope you'll help share the word. Record clearing. Prior to 2020, a conviction in Georgia would stay on a person's record for life, forever, and it caused obviously a lot of barriers to employment and housing. So the first time after Senate Bill 288 passed, convictions can be restricted and sealed, which is the official term for expunging a record. It was a huge step forward, but we continue to expand and improve that, which my colleague Brenda will talk about a little bit later. And again, I'll put something in the chat about how you can learn about if you're eligible for record clearing and attend a First Friday presentation that we do at our office every month. So that's what we've done in the past. So I just want you to be aware of what these options are under the law now. And now I'm going to do a very quick overview of our policy priorities for 2026. And then my colleagues will give you more detail. So the first bill we'll talk about today is Senate Bill 207, occupational licensing. So it'll open opportunities not just for jobs, but for careers in licensed industries. So anything in licensed industries, it ranges from plumbing and barbers to nurses and accountants, funeral home operators, many careers. And so that's a law that we're pursuing with Senate Bill 207. It also expands, Senate Bill 207 also expands options for record clearing. And my colleague Brenda will talk about that as well. And then HB 162 will modernize the First Offender Act, so it provides the true second chance that it should. And then the last bill is HB 535, and it relates to probation revocation hearings and how time served is counted. So given how many people are on probation in Georgia, it will be a very impactful bill. So to give you a little more in-depth on each of those priorities, I'm now going to pass it to my colleague, Wade, who is our policy consultant and lobbyist with Gold Dome Partners.
Thank you very much, Anne. And thank you everyone for joining us today. I'm going to focus on SB 207, what Anne mentioned, occupational licensing, and also record restriction. If you have been on this kickoff webinar in years past, you will have probably heard me talk about and us talk about occupational licensing reform a few times. And so I'm going to get into, in just a second, just a little bit of the specifics of where the bill stands, what the next steps look like for us in terms of finally getting it over the line after it has had incremental progress for the last few years. But first, just kind of want to frame generally what SB 207 does and what the need is. So this map here shows that our efforts to modernize Georgia's approach to how arrest and conviction records are considered when people are applying for a government license to hold a job is not something unique to Georgia. 80% of states since 2015 have updated their laws to make that process of, again, solely just the arrest and conviction record evaluation, to make it more transparent, to make it more fair, to amend it in a number of different ways. And so what we're doing here in Georgia is trying to build off of the best practices from all those other states, those 80% of other states in the country that in the last decade have taken a look at this issue. So we at Georgia Justice Project, what we see most commonly is for our clients who have diverse talents, diverse interests, and want to accordingly pursue a diverse set of career fields, that about 1 in 6 of our clients, which maps onto overall numbers about 1 in 6 jobs, about 1 in 6 of our clients are interested in a licensed field, pursuing a career in a licensed field. That can range anywhere from being a doctor or a nurse. Nurse is a high demand occupation in this state. We need more nurses, and lots of our clients have strong caretaking backgrounds and are interested in advancing their careers at the many various levels of nursing. It could be a fingernail technician or a barber. There is a very wide range of occupations that are touched by licensing, where you just need government clearance to be able to work that job or pursue that career. Given that so many of our clients are interested, the most common question we get is, hey, I have XYZ on my record. Can I move forward? We're we like to think that we know what we're talking about pretty well in the state when we talk about barriers that an arrest or conviction record might impose on someone for their many various goals. But even we can only give a guess, because there's no way to ask a board ahead of time, hey, here's my record. Should I pursue my education? Should I pursue my training? Should I move forward in pursuing this career? Instead, current law says you have to get all your education, do all your testing, invest your years and your dollars before you can get that answer at the very end of a process. And so what we're trying to do is make that a more transparent process where someone can show their record up front, say, am I able to move forward? But not just show their record, be able to show everything that they've done since. Here's who I am. Here's holistically who I am, all the positive things that I have done, so that can be holistically evaluated. when a board or agency decides, yes, you can move forward, go pursue your education, go pursue your training. Your record isn't going to be a barrier here. You can move forward in this career. That is what we're seeking to do, and that's what SB 207 does. Now, a little bit of, again, sort of catching people up to where the bill is now. First, I want to flag that if you look the bill up online right now, you will see a one-page version that only affects firefighters. I want to call that out because that is not kind of the final version of the bill that we are seeking passage of. It's a result of some kind of procedural stuff that I won't get too in the weeds of. Feel free to reach out to me if you want to know all the details. But to sum up, SB 207 in its current form has gone through a multi-year process. Last year, leading up to the final day of session, the House and the Senate kind of finally came to an agreement of what the final version of this bill is going to look like. It is still does all the things that I just named that we hope it will do. That in the kind of procedure of the last day of the different versions that the House and Senate voted on, the two versions that they each voted on were not identical. When that happens, the bill moves back, kind of ping pongs from chamber to chamber, from House to Senate, until they agree on a final version that is identical, so that they can send one version to the governor for the governor's signature. So long story short, while you see a one-page version online, there's about a 65 or 70-page version that the Senate voted on the last day of session. And it's that version that we're hoping that we have an agreement on, that we get the House to vote one last time to say, yes, we agree to that version. Let's send it to the governor for his signature. And so that's what we're advocating for. Where SB 207 sits right now is just needing the House to call it for a vote. It's done with committees. It's done with drafting and amendments. It's done with all that. Knock on wood. Procedurally, the only thing left to do is on the House floor to say, we're calling it for a vote. Let's send it to the governor. That final page version that's not online, but is about the 65, 70 page version that we came to in the dying moments of last year's session. So with that, I'm going to pass off to our partner, colleague, friend, Nancy Palmer. Nancy is the Vice President of Government Affairs at the Georgia Chamber of Commerce, and the Chamber has been a great champion and great partner in this work, not just with SB 207, but with a number of second chance bills over the years. So without further ado, I'd love to kick it over to Nancy to talk a little bit about the Chamber's support.
Hi, everyone. Thanks for having me. I am joining you from a storage room in the basement of the Capitol, so I apologize for the background. But Wade invited me on to talk a little bit about what the Chamber does in working with GJP at the Capitol during session. I'd like to note that Tasha Allen with the Georgia Chamber of Commerce is also on this call. Tasha really leads up our relationship with GJP in the off season. And then during the legislative session, Wade and I work very closely together to work on legislation. As Wade mentioned, Senate Bill 207 has been a top issue for us. We did scorecard this issue, not needing to know our scorecard process, but that is just to say that there are only 8 or 10 bills in a year that we would put at that level of importance for us. And so we are working with Wade and the House leadership to make sure that that bill does get the agree that it needs to get. It is a simple procedural vote. So we have our fingers crossed. We've been working on this one for a very long time. As the Chamber approaches issues like this, there are a few things that we're always looking for and with legislation to help out from the business community standpoint. We're, of course, focused on workforce. So that means any bills dealing in second chance hiring are bills that we're going to get engaged in. We are constantly looking for more workforce. When we have our CEO survey every year, we consistently hear 2 big problems. 1, not enough workforce. 2, not enough housing. So even though these issues might not feel like at the top of mind for businesses, when the big business community gets together, which is what the chamber does, these are the issues that come to mind. And so we work with GJP regularly on anything dealing in second chance hiring, making it easier, smoother, faster, better, so that people can get back to work. Additionally, we've done some work with you guys on driver's license issues. Most people need a driver's license to get to work, and the Georgia Chamber of Commerce is a big fan of people getting to work. And then the other thing that I'll highlight is we've worked with you guys in the past and we'll continue to work with you on issues relating to criminal records. The GCIC system has its challenges, and of course, the chamber is interested in making sure that criminal background checks for employment are accurate and timely. We have many challenges in the state as to making sure that those are accurate and timely, often to the detriment of both employers and potential employees. So that is something that we're focused on. It is, of course, a very big and complicated problem, but these are kind of the big areas in which the Georgia Chamber works with GJP down at the Capitol to make sure that we are facilitating as many people getting back into the workforce as possible and smoothing that pathway for both our employers and potential future employees. With that, I'll turn it back over to Wade, and again, mention that Tasha Allen, who works with our team at the Georgia Chamber, keeps in touch with you guys as well, and she'll stay on the call.
Thanks so much, Nancy. It is always wonderful to work with you and Tasha, and we appreciate your support, ongoing support through thick and thin on these things. So I'm going to pass off now to our legal director at Georgia Justice Project, Brenda Smeaton, to talk a little bit about our record restriction bills.
Thank you, Wade. Good afternoon, everyone. I am so happy to be with you today and with the rest of our team and our guest to talk a little bit more about the pending bills we are working on, particularly as it relates to record clearing. And I can see from the chat and from our registration list, actually, if you can go back just one slide, Emily, that a lot of you that are on the call have been with us since the beginning of this journey down at the Capitol, which sometimes can be a little bit crazy. So we appreciate your ongoing partnership. So if you've been following our work for a while now, as Doug mentioned, it was record clearing that first got us into our policy work, and it continues to be a priority for us. Our amazing team of attorneys and legal assistants on our records team assist hundreds of folks a year who want to clean up their record. Overwhelmingly, those folks that come see us, they tell us they want to clear their record to get a better job or build a career. And we know, and the research shows us, that record clearing helps to do that. Also, as they work around the state, our team gets to see what's going on with the current law. And there are a few things that we are hoping to fix this year and some slight expansion. So we also know that many of you are anxious to see a significant expansion of record clearing, and we are too. And we think that some of these small steps that we're hoping we can take this year are building blocks towards that larger change. So first up, SB 207, which, as Wade mentioned, in addition to occupational licensing reform, expands who can clear their record and when. So what does it do? You can read a full explanation on our website on the policy page, but here are some highlights. One, it removes a delay on sealing for trafficking survivors who get their convictions vacated. It creates an easier path to seal pardoned felony convictions as long as they are not serious violent felonies or sex offenses. It expands which misdemeanor theft convictions can be sealed. So right now, the only misdemeanor thefts that can be sealed are theft by shoplifting or refund fraud. And we talk to a lot of folks all the time who have theft by taking or other minor theft convictions who we can't help. So we're hoping that that changes this year. And then the other change that I'll highlight, this is the big one, it removes the lifetime limit on the number of misdemeanor convictions a person can have restricted and sealed. So why is this a big deal? One, it's focused on the now. Has a person stayed out of trouble? Have they demonstrated that they are rehabilitated? Not what's in their past. And importantly, it clears an obstacle to clean slate reform in the future, which could automate the sealing process for some convictions. So it's impossible to do that right now when a person has to pick and choose because they can only get 2 lifetime misdemeanors expunged. So hopefully this will move us towards clean slate. So these changes will have a huge impact for thousands of individuals in Georgia and lay the groundwork for that future reform. Also on record clearing, as we mentioned, is HB 162, which improves the First Offender Act to be the second chance it was meant to be. So the First Offender Act has been around since the 1960s, but the law has not kept up with how modern background checks work. So what's the issue? Let's say I go to court on a drug possession case, and because I've never been in trouble before, the judge sentences me under the First Offender Act to 3 years probation. If I successfully complete my probation, it's not a conviction. And the law says that employers can't hold it against me, that I get that second chance. But under the current law, what actually happens is a private background check company, they report my first offender sentence when I'm sentenced, and it keeps me from getting jobs often during my sentence. So let's say even with that barrier, I still manage to do everything that the court tells me to do. I stay out of trouble and I successfully complete my sentence, which overwhelmingly most people on first offender do. Even after I complete my sentence, the background check company still has those records in their database from 3 years ago, and it keeps haunting me. So I don't get the second chance I was promised. So under HB 162, those records are sealed at the time of my sentencing, and the private background check company never gets them. And they would only be unsealed if my sentence gets revoked. Okay, and then the last thing I'm going to cover on the next slide is HB 35, which will have a real concrete impact in reducing incarceration. So it has long been the practice that if a person was incarcerated for a probation violation and then their probation was revoked, that they would receive credit for the time that they served against the sentence they received while they were waiting for that revocation to be resolved. Just like, if someone gets arrested and they go to jail while they're waiting for their case to be resolved, if they're convicted, they get credit for that time in jail. But a 2024 Court of Appeals decision in the Kellum case said, the language in the law doesn't really allow for time served to be counted. So let me give an example. Say I'm serving a 2-year probation sentence and I violate my probation and I get arrested. I sit in jail waiting for 3 months for my revocation hearing. The judge revokes my probation and sentences me to 1 year in prison. Prior to this decision, I would have had 9 months left to serve. But under this decision, I would then be in prison incarcerated for a total of 15 months, including the time I already did. So I'm receiving a double punishment. So this bill would fix that issue and reduce unnecessary incarceration, so having a huge impact on folks' lives. And now I am going to turn it over to my wonderful colleague, Emily Spears, who is going to talk a little bit more about our court notices work.
Thank you so much, Brenda. I appreciate it. Like Brenda mentioned, my name is Emily Spears. I am a staff attorney here at Georgia Justice Project, and I am really excited to be with you all this afternoon during this lunchtime hour to look ahead to some of our Smarter Justice initiatives. And the 2 initiatives that I'm going to be talking about today are not initiatives that we are actively going to be pursuing via legislation during this legislative session, but they are 2 policy priorities that we are working towards here at Georgia Justice Project. Both of these initiatives I'll talk about are called Smarter Justice because they both focus on reducing the carceral footprint and involvement in the criminal legal system by simply making our systems run more efficiently. So it accomplishes a big impact just by streamlining processes and making sure that our system works smarter and not harder. So I'm excited to first cover with you all these 2 priorities broadly, and then we're going to dive into some more specifics. But as Brenda mentioned, the first priority is around court notices and text reminders. So what we know is that our system punishes forgetting. Ultimately, Every day, every month, every year, we have so many people who miss dentist appointments, miss doctor's appointments, miss vet appointments, oral changes, things that they've scheduled that are priorities and are important in their lives. And when someone's life gets in the way and they're overwhelmed and they forget something like an important doctor's appointment, the consequence is that they reschedule that appointment. However, for court dates, the consequences are much more severe. So if life gets in the way and someone misses a court date, even for a low-level traffic ticket, they end up with consequences such as a warrant out for their arrest, jail time, more expensive fines, and a suspended license. So a simple mistake can really cascade and cause devastating consequences on someone's life. However, those same interventions that get someone to a doctor's appointment or get someone to a dentist appointment can be used in the court context as well. So a simple text reminder could actually prevent a lot of missed court dates and get people into court to resolve their cases and to prevent these ripples from becoming waves in people's lives. The second initiative actually focus on both of these, where it talks about how forgotten charges can actually become future barriers. So we see this a lot in the people that we work with out at Metro Reentry Facility, a prison in the Atlanta area, where people who serve long prison sentences don't know they have lingering warrants, often from low-level cases, often from something like missing a traffic ticket. And this frustrates their reentry as they're preparing to reenter society, as they're preparing to reenter the workforce, but they have barriers such as warrants that keep them in jail longer and block their access to opportunities. So both of these initiatives we're going to talk about today really can be summed up in an ounce of prevention is worth a pound of cure. We're thinking upstream to how can we get people to court to resolve their cases so that it doesn't become a waterfall and cascade of consequences longer down the line for them. So to help us talk about this today, I'm excited to introduce to you Shannon McAuliffe. Shannon McAuliffe works with Ideas 42, which is a national nonprofit that focuses on behavioral science. She is the Associate Managing Director of the Safety and Justice team and leads system implementation of the Unwarranted Initiative to improve court date communications nationwide. And excitingly, so far, Unwarranted has prevented over 125,000 missed court dates and their resulting warrants and jail time, and in turn has saved $357 million. And I'm sure that number is even higher now. So y'all are in for a treat. I always love listening to Shannon, and we've appreciated her partnership as we have been focused on implementing improved notices and reminders here in Georgia. So I'll turn it over to Shannon.
Thank you so much, Emily. I really appreciate the introduction and the setup of the problem. So missed court dates are something that a lot of systems don't really appreciate. So, for example, missed court dates drive jail admissions. It's the most common reason for jail in North Carolina, which is crazy. I mean, it's more common than a DUI. Just missing court. In North Carolina, they have about 250,000 missed court dates every year that can cause jail. Now, in Georgia, we're not exactly sure how many missed court dates drive admissions, but we do have one figure, and that is that there are about 105,000 license suspensions in Georgia. Now, that means there are many more missed court dates because you have to miss the court date and then you have to go beyond the grace period, et cetera. For actually to have your license suspended. So as a very baseline lowest level would be 105,000 missed court dates a year in Georgia, but it's probably many more. It's super expensive. So missed court dates cost the community about $2,850. It costs about $1,500 to the system, and that's for court staff, rescheduling, issuing the warrant, reassigning attorneys, arrest, booking, and jail. For the person, it costs about $1,350, right? So they lose out on employment, they might have bail loss, they don't get their benefits, etc. So it's a really expensive problem. And the costs add up quickly. So it's almost hard to imagine how it adds up. But now let's say Georgia experiences 105,000 license suspension. So that's many more missed court dates. So let's just go with that number. So what does that cost the system? Not the community, but just the system. It's $157.5 million. So what we want to do is we want to improve court date communications. Again, an ounce of prevention is worth a pound of cure, to let people know what their court dates are so that they don't miss court and there are no warrants or resulting jail and fines. So how we do that is we want Georgia to improve all court notices. So yes, it's the Georgia citation, the UTC, and any other court form that has a court date on it. So things like the UTC, release forms, bond forms, mailed letters, postcards, grace period postcards. And also we want them to start sending texts and emails to people. By doing this, by revising and just improving your forms, it's a few tweaks. It's putting the court date at the top. It's making the consequences really salient. You can reduce missed court dates by 36%, and that is proven in an RCT. It means 1,000 fewer warrants and license suspensions in Georgia, and a savings based on that 105, again, low bar number, a savings of $60+ million for the system. So that's what we're working on with GJP, and we're also working on it with the new CMS system, which I think Emily is going to talk about next.
Thank you so much, Shannon. We have really appreciated working with Ideas 42 as they have helped other jurisdictions nationwide also accomplish improved court notices and text reminders. And we're excited about the progress that's ongoing in Georgia here already. So I wanted to spend a moment and talk with you about what we are doing actively to help improve court appearance, help reduce license suspensions and warrants, and help make sure that jurisdictions across the state are equipped to use improve court notices and to send text reminders. So the first thing is something that Shannon just mentioned, which is the statewide court management system. The statewide court management system is currently being developed by the Administrative Office of the Courts, and it will be available to a large amount of courts statewide. And we're excited about working with the CMS team to make sure that the CMS system is equipped to send reminders once it's up and running fully in the state of Georgia. We're excited to say that the Administrative Office of the Courts has adopted those recommendations and will be implementing them into the system so that it will already be in place for courts to start using if they opt into using that new case management system. Additionally, a text reminder is only as useful as the contact information that the state and the court has on file. So we are working to improve the uniform traffic citation to, one, make it more readable. If you've gotten a ticket in the state of Georgia, you may notice that it can be a little confusing to read your citation. I won't ask anyone for a show of hands, but I know from personal experience, it can be confusing. So we're working to improve and streamline those citations and add a phone number field so that courts can have up-to-date contact information to send reminders and prevent those consequences that we talked about. Additionally, we are working with individual courts to help ensure that individual courts can use reminders and are using them effectively. There are some jurisdictions in Georgia that are already effectively sending reminders and seeing huge impacts to their court appearance because they are already implementing the solutions that we're advocating for here. So we are working with Atlanta Municipal, Fulton County, Cobb County, and other jurisdictions to equip those jurisdictions to go ahead and start sending reminders and see the impact that it can have for those people who have court dates in their court. Ultimately, it's a short-term investment for a long-term impact. You just heard Shannon run those numbers, and that's one of the reasons we're excited about text reminders and court notices, because it has a massive impact on our clients' lives and across the lives of many Georgians. And it is really a win-win-win because it also makes brings common sense efficiency to courts and other agencies in the state as well. All right, part of getting the word out is making sure the right people are at the table and are understanding the impact that court notices and text reminders can have. So recently on November 21st, we held a court notices and reminders convening at the Home Depot Support Center, where we brought together over 45 attendees to discuss the importance of improved notices and how to get reminders up and running. That included judges, clerks, AOC staff, community activists, and attorneys who were all at the table to talk about this important problem and an easy, efficient solution. Shannon actually was present as well to give her insight into how it's effective. And Justice Verda M. Colvin actually provided remarks to share her support for this work. And I wanted to share a quick quote where she said, we ensure true access to justice when the public knows when and how to fulfill their judicial obligations. There is no need more basic. So we appreciated everyone coming out on the 21st, and it's an example of the work we are doing to move this work forward in Georgia. Lastly, I talked about 2 initiatives in our Smarter Justice campaign, and I wanted to spend a moment to talk about the second, which is about holds and detainers for people who are in custody. So I alluded to this earlier, and I talked about the work that we've been doing out at Metro Reentry Facility and how we've been seeing holds and detainers be a huge barrier to individuals who are trying to reenter society and are going through all of this effort to make sure they are prepared for a successful reentry. Through our individual representation, we're seeing how lingering warrants and legal issues disrupt that reentry and actually lead to longer incarceration. At Metro Reentry Facility, we work to solve these one at a time, but it's made us stop and zoom out to think, is there a more efficient way to do this systematically throughout the state? So we are currently looking for systematic solutions to catch active warrants, probation violations, and pending charges so that people who are in custody have opportunities to efficiently resolve these warrants and holds while they're in prison. And they don't have to wait until they're ready to go home for something to pop up or for them to have to go and resolve additional charges after they've already prepared for their reentry. So we're currently building model legislation and support for this initiative because we do think it's really important. And as I mentioned at the beginning, it ties into work smarter, not harder. How can we streamline and make efficient solutions that not only work for systems, but work for our clients and have massive impact for the lives of Georgians across the state? All right, and with that, I'm actually going to pass it back over to Anne, who is going to talk about how you can stay plugged in with our work here at Georgia Justice Project.
Thank you, Emily. Yes, my name is Ann Colleton, and I know I spoke earlier, but I don't think I introduced myself properly. So I'm the Policy and Outreach Coordinator at Georgia Justice Project. So if you have questions about our policy work, you can reach out to me and I can get you connected with the experts who on that topic. So just before we close out, if you have other questions, please put them in the Q&A box, and we have a few more minutes to answer those. And we'll just close it out, just some more resources, how you can connect with Georgia Justice Project. So if you need legal help with the things that we talked about early on in the presentation about laws that we have passed already about early termination of probation, record clearing, or driver's license suspension, you can scan that QR code, and I'll put something in the chat as well to the link to find out how you can get resources. And a lot of this is things that you can do for yourself. So you can write your own pardon. We have information on our website about how to apply for a pardon, how to get your license back and use the pauper's affidavit. How you pursue early termination of probation does not require a lawyer, but we have a lot of materials on our website about how you can do that. And since this webinar is all about policy change, sign up to receive our action alerts if you don't already. So get those emails from us to learn about what's happening. And of course, to do all of this work requires money. So if you're in a position where you can donate financially to GJP, we of course would appreciate that as well. And then we want to leave you with some action alert, calls to action. What can you do? So when we do send you an email about pending bills and it's up for a hearing, it's up for a vote tomorrow, we really encourage you to make that phone call. We specifically asked you to make a phone call. So instead of taking 10 seconds to click something to send an email, we know that Georgia lawmakers are very, very busy and will pay more attention to a phone call. So it might take you 2 minutes instead of 10 seconds, but we will provide all the talking points, the phone number, everything that you need to have a 2-minute phone call with a staff member in a legislator's office to help us get those bills across the finish line, because they are very close. They've already passed one chamber and are very close to the finish line, but often that last 5 yards or 6 inches is the hardest, so we can use your support with that. Also want to make sure that you know your voting rights, because policy change is all about voting, right? Who we get into office, how they vote, how we encourage them to do what will help the community. So just want to make sure everyone knows that if you are not currently serving a sentence for a felony conviction, you can vote. You are not disenfranchised forever. As soon as your sentence is complete, all you have to do is re-register. You don't need your record expunged or a pardon or anything special other than just completing your sentence. And as we mentioned before, a First Offender Act sentence is not a conviction unless the status gets revoked. So people who are serving a First Offender Act or conditional discharge sentence do not lose their voting rights and can vote while under that sentence. So again, I put the links in the chat to learn more. And the last thing is attend Justice Day. Justice Day was started in, I believe, 2014 by the Georgia Justice Project. And it has since evolved and expanded to include a lot of partner organizations who are part of the Justice Reform Partnership. So Georgia Justice Project is one of those members. And that is an in-person advocacy day at Central Presbyterian Church, which is directly across the street from the Capitol. And we will be part of a legislative panel in the morning where we will be talking more about the same bills that we just did, but in current real time, like what's happening that day. Did they pass? Did they not? Did they need something? And other organizations will be doing the same. So it's a great opportunity to learn about what's happening in the legislature in the criminal legal system world. And then there will be an opportunity to actually go speak to lawmakers across the street at the Capitol. So we encourage you to sign up for that. The link is in the chat, or you can use that QR code. So just checking if there's any other questions. There's one more question in the chat and we will, or in the Q&A that we can respond to. And then I think we are done unless some more questions come in. And Jim, we can also email you later because I think we have your contact information. So I believe that that is it. And again, we thank you so much for coming and we appreciate your support. Thank you.